A very important status conference and hearing coming up this Friday in the Courtney Clenney case. Now, Courtney Clenney case is the case of the OnlyFans model Courtney Clenney, who is being accused of murdering her boyfriend, Christian Abumsali. And we've seen some of the videos already of some of the altercations that they've had in an elevator in what appears to be her apartment. And from those videos, it definitely looks like she is the aggressor and he is much more being the defensive one. However, her claim in this case is that she was acting in self-defense, and this was not actually a time where Christian was being the aggressor and she was acting in self-defense. So this is all going to still be played out during trial. We have to see some more discovery in this case, and I don't believe we have a trial date yet. Maybe that's going to be something that we hear about on Friday. But more importantly on Friday is what the judge has to decide about whether the judge is going to grant Courtney Clenney bond. And this is already a few years in the workings. Why is that? We're going to be going through that all today to catch you up to speed about what's going on in the Courtney Clenney case. And that way you'll be ready on Friday to watch this. And guess what? You'll be able to watch it with me because I'm going to be live streaming this at Brother Counsel Studios. Join me 9:30 Friday for this very important status conference in the Courtney Clenney case. I'm going to be live streaming it. Join me. We'll have a good time watching it, and I'll give you my real-time analysis. So we are going to be jumping into the judge's findings on the Arthur hearing that occurred. And then we're going to be discussing what happened after the Arthur hearing, which is why this issue was opened up again. So before we do, I do want to give a shout out to the sponsor of this video, which is the Suit Depot, a wonderful store that sells very high quality products for very reasonable prices. And only my listeners get a 10% off of discount from anything that you purchase from that store. The link is in the description. Hit that link. Go shop away. Very nice apparel, and you can get 10%. Just type in Brother Counsel, all lowercase, no spaces, in the coupon code box when you are checking out, and you will get 10% off. All right, let's jump into what the judge found after the Arthur hearing. So an Arthur hearing is just simply a hearing where the judge is going to determine whether she's going to grant this defendant bond or not. So they have some witnesses, they talk about the case, and we're going to be seeing what the standard is. It's a little bit of a different standard than what we're used to, so we'll see what the standard is, and we'll see what the judge's findings were, and then we'll talk about what happened after this Arthur hearing. So let me pull this up for you. This is the judge's findings after that Arthur hearing. And this was in 2022. So this is a while ago. In Florida, a defendant charged with an offense punishable by life imprisonment whose guilt is evident has no substantive right to pretrial release. In this case, defendant is charged with an offense punishable by life imprisonment. That is what Courtney Clenney is being charged with. Defendant's guilt is evident. She's being charged with second-degree murder, by the way. Defendant's guilt is evident, and the presumption of her guilt is great. So this is the judge's finding after the Arthur hearing that her guilt is evident, and the presumption of her guilt is great. To this court, the meaning of the phrases evident proof and great presumption of guilt have always been ambiguous. However, language in State v. Perry gives some guidance to trial courts to determine whether the state has met its burden in an Arthur hearing. The state's evidence, although not insufficient to convict for a capital or life offense, is arguably impeached in substantial respects by other evidence or is rendered doubtful by substantial contradictions and discrepancies in the state's case. The proof is not stronger than beyond a reasonable doubt, and accordingly, the accused is entitled to pretrial bail as a matter of right for such offense. So this case, State versus Perry, really helps out the defendant in a way, because again, it says that if the evidence is arguably impeached in substantial respects, or the defense can present some evidence which would render some of the evidence that the prosecution is presenting as doubtful by showing some contradictions or discrepancies, well, then the defendant should have bail. The court does not believe the state's evidence was rendered doubtful by substantial contradictions or discrepancies during this Arthur hearing. So even though we have this State versus Perry, this case which seems to lean and bend in the favor of the defendant, however, after the Arthur hearing, the court did not believe that the state's evidence that they presented was rendered doubtful, which means that the judge is saying that she believes that the state's case here is extremely strong. There's no dispute that defendant killed victim in this case. The only factual issue is Now, the only factual issue in dispute is whether the defendant was acting in self-defense and whether this claim rendered the state's evidence doubtful. Clearly, defendant and victim had a sadly volatile relationship. There is ample evidence of communication in the form of texts, videos, letters, and audio recordings of how unhealthy their relationship was. This was not a great relationship. However, from the evidence presented during this hearing, the court does not find defendant's claim of self-defense on April 3rd, 2022 credible. So that was the date of the murder, April 3rd, 2022. And she's claiming that it was an act of self-defense. But after the evidence presented during the Arthur hearing, the court does not find that the defendant's claim of self-defense is credible. Therefore, this claim does not render doubtful the state's case. Defendant's statement to police about her involvement in the victim's death is not supported by other evidence from the hearing. Defendant's version of how victim's stab wound occurred is not supported by the evidence. In her statement to police, defendant stated that she threw a knife at the victim from over 10 feet away. So that was the defendant's statement. This is what Courtney Clenney's statement was, that she threw the knife at the victim from over 10 feet away. That's the defendant's interview on April 3rd, 2022. However, the medical examiner testified, and this was during the Arthur hearing, the medical examiner testified that the victim was killed by a knife wound that went down into the soft tissue and into the muscle and injured the subclavian artery. I may have not said that subclavian properly. So if you're a doctor or medical professional, I apologize. He went on to testify that the victim's stab wound was 8 centimeters deep and traveled from front to back in a slightly downward trajectory. The medical examiner opined that at least 8 to 12 pounds of pressure would have been used to penetrate the skin and muscle into the artery itself. So this was a deep wound. When asked whether victim's stab wound could have been caused by a thrown knife, the medical examiner answered no. So the medical examiner testified in the Arthur hearing that this wound that killed Christian was not able to be given. It was not able to be given by throwing a knife. That couldn't have been the cause of this injury. And again, that's her whole story. Courtney Clenney's whole story is that she stood back 10 feet and threw this knife in self-defense. Well, the medical examiner said, sorry, it's not possible that would have caused this wound. Defendant's speculation over whether the knife could have been pushed in, whether either victim or defendant was trying to remove it, is not persuasive. So they tried to argue in the Arthur hearing that, well, maybe when the victim or defendant was trying to remove the knife, that's actually how it got pushed in more. So even though, let's say, when she threw the knife, it didn't go in as deep as the medical examiner found the wound to be, but maybe after she threw it and they were trying to struggle over that knife, maybe that's what pushed it in more. So the court found that that's speculation and it's not persuasive. Additionally, defendant's contention that she grabbed the knife only to scare defendant and threw it at him with no intention of injury is undermined by the fact that defendant had intentionally cut or stabbed victim twice in the 6 months leading up to this incident. So there's a history of her stabbing him. So she tried to argue, again, this is her attorneys on her behalf, that she only grabbed the knife to scare the defendant. And when she threw it at him, she didn't really want it to hit him. She was just trying to scare him. However, that's undermined by the fact that she actually stabbed him in the past, 6 months leading up to this incident. On October 8th, 2021, defendant stabbed victim in his leg. On January 30th, 2022, defendant cut victim in the face, causing multiple lacerations, which required stitches. I mean, this is just a couple they're living with each other, and this is what goes on. I mean, this is horrific. Defendant clearly had no fear of using a knife as a weapon within close proximity to victim. She had no problem with that, as there are no allegations that a thrown knife caused those injuries. Although defendant claims victim held her down by the neck at some point prior to the incident, so again, that's another argument that was made, that he actually was holding her down by the neck. That's why she felt that her life was in danger, and that's why she grabbed this knife and threw it at him, even though she was just trying to scare him, according to her. There is no physical evidence of this. So there's no evidence that he grabbed her neck. Her description of this event changed slightly each time she explained the event to the police, making the statement less credible. Although defendant did have bruising on her body, so there was some bruising found on her body, notably there was none on her neck. So there's no bruising to her neck. This is what happened in the Arthur hearing on in 2022. Photos and videos show that the only significant bruises were there. The only significant bruises were there prior to the incident, as was the damage to her fingernails. So any injuries to herself, to her body, these bruises, there's proof, photos and videos, that these were actually there before this incident, before April 3rd, 2022. So you're right, she did have some bruises, but those bruises you see very clearly were actually there before, from pictures and from videos, were there before this incident. Evidence clearly shows that the defendant was on the phone with her mother during some portion, if not all, of this incident. However, during a 20-minute recorded interview with police, defendant's mother never once mentions that there was any physical violence or verbal threat from victim toward defendant on that day. Defendant's mother says that she heard yelling and that defendant told victim to leave, but never once does she say that defendant was in fear that day or being harmed in any way. Immediately after the incident, defendant's mother texts her daughter not to speak to police without an attorney, describing the incident as self-defense. However, when asked by police whether she heard her daughter say anything that day, specifically whether she heard any threats from victim toward defendant, defendant's mother says nothing. So the mother of Courtney Clenney did not say that she heard any sort of threats that were made by Christian towards Courtney, and she didn't hear anything about that, and therefore, but still, she's going to be arguing that this was self-defense. She does not tell police of any verbal threats to the defendant or a physical attack by victim that day, and they were very, very closely they were on the phone very closely to the time of when this actually happened. So you would think that she would have picked up on something, that something is escalating over there, and she's getting in fear, but that did not seem to be Courtney Clenney's mother's statement to the police. At this point, evidence of defendant's use of self-defense on April 3rd, 2022 is not credible. Based upon the evidence from this hearing, the court does not believe the state's evidence was rendered doubtful, which is the standard, by substantial contradictions or discrepancies shown by defense. Therefore, the court finds that the state has met its burden of showing that proof of defendant's guilt is evident. The court finds that there are no release conditions which this court believes can assure the appearance of defendant at future hearings and or protect the safety of the community. These are the factors that the court has to take into account also. That can the court be assured that the defendant is actually going to show up at future hearings, number one, and number two is that if we're going to grant this defendant bond, is that going to cause any safety concerns for the community? So here we go. Defendant has no ties, meaning there's a flight risk. Defendant has no ties to Florida and ample means to leave the country were she to choose to do so. I mean, she has plenty of money. She has no ties to Florida, so she may be on the next plane out of here. The defendant has substantial funds at her disposal and the ability to make more outside of the jurisdiction of the United States, meaning she can continue with her OnlyFans pages. The state is correct that defendant's criminal history in previous cases shows defendant did not abide by the terms of her pretrial release conditions. So again, this is the state arguing that Courtney Clenney has a criminal history in other cases, and she did not abide by the terms of her pretrial release. So she has a history of not complying with the conditions that are put on her. At the very least, picking up new cases when out on bond. In those cases, defendant was facing little jail time and still did not abide by the court's orders. The court is concerned about what defendant might do when faced with the possibility of a life in prison. The court does not agree that placing defendant on house arrest with her parents in Texas is an appropriate form of release in this case. This finding does not end our inquiry because the state filed a motion for pretrial detention. Motions for pretrial detention can be filed at any time, yada, yada, yada. Okay. Continuing, in this case, there are several factors that demonstrate defendant's threat of harm to the community and the need for pretrial detention. As noted above, the defendant has no ties to the state of Florida. This court has considered the nature and circumstances of the offense charged. As stated above, the defendant is facing an offense punishable by life, namely second-degree murder. So, essentially, that is... wait, there's a little bit more here. Hold on. Okay, so they go through some of the more factors here, and therefore the judge decided to not grant bond initially after this Arthur hearing. Okay, so some pretty compelling, strong evidence. The medical examiner said that there's no way that she threw this knife that did not cause this wound, and any sort of argument that maybe it got pushed in by them in the scramble after, that's also not supported by evidence. It's just speculation. And of course, if she is let free from prison, there's a very tremendous flight risk. She has a lot of money. She has no ties to Florida. So therefore, the judge denied the bond. Now, denied her bail. Then there was a hearing. There were some more hearings. And there was an expert that was retained by Courtney Clenney, by her defense team. And this is what happened in that hearing. They did a testing of what it would look like if somebody threw the knife at a human. And what they did was, in order to reenact this, this is the medical examiner along with another expert, they went and they tested throwing a knife on the carcass of a pig, because the carcass of a pig apparently is very similar to a human. Pigs have very similar, I guess, body makeup as humans. Bones, muscles, tissues, soft tissues, things like that, skin. So therefore, that's what they did. And this is what it looked like. I'll play it for you. I'll show you exactly what it looked like. Let's go ahead to where they played it. Here it is.
Tried to the court. I mean,
take a look at this.
Do you know if there was
so here we go.
sound recorded or not?
We did not get sound recording.
Can you describe to the court? I mean, obviously we can see what's going on, but from your observation as an expert medical examiner, what, if anything, does this demonstration show?
So that is the testing that they did with this medical examiner, who's now serving as an expert for Courtney Clenney. And this medical examiner testified that actually the wound could be used, this wound could have been caused by throwing a knife. And that was what that test was there to prove. So that is what he testified to. Now, also he testified, remember, that the judge had a finding in the Arthur hearing that we just read, that there was no injuries to her neck. And this medical examiner actually testified that there was some irritation and some redness that you could find, that he was able to find by pictures of her from photographs after this incident. So he claimed that there is some sort of evidence that she was actually grabbed by the neck. So you have this medical examiner. Also, the medical examiner testified that if this would have been, according to the knife that was used, if this would have been a stabbing death, then you would have expected to see some other injuries. So number one, you would have expected to see some defensive wounds on Christian, which you did not find. You also would expect to find that perhaps there'd be some sort of abrasions on her hand over here. When you stab someone, you may get some abrasions when the knife goes in very deep. You might get pushed against your own hand. You didn't find that. And also sometimes there's slippage. Sometimes you actually, if someone's stabbing someone like this, then their hand may slip a little bit and they may get some cuts on their hand. And you did not find that either with Courtney Clenney. So he testified very, very last month, this medical examiner. And now all of a sudden, can that mean that there's doubt now about the state's evidence? And if there's doubt, substantial doubt, then maybe now the judge could grant her bail. Now, again, there's still a flight risk, and there can be some other risks why maybe she's not going to want to grant bond. And that would be the safe bet here, that she's not going to grant bond. She's, Courtney Clenney's facing a possible life sentence. So the chances that she's going to be getting granted probably not that great, but it just makes it for a more interesting argument, because now we have this medical examiner that's testifying on behalf of Courtney Clenney that this injury could have been caused by throwing the knife, even though and he said that it doesn't take a lot of force. It can even be by a woman like her makeup with not so strong. Still, they could have caused this wound by throwing the knife, as well as that she could have been grabbed by the neck a little bit time before. So it's completely changing the entire case. Now, I believe also, and I think I've read some things about this case also, that there's going to be a battered spouse syndrome argument in this case as well. We just heard about this from Sarah Boone. We talked a lot about it in Sarah Boone. And what we're going to probably run into also is an interesting argument about, was this actually an accident or not? Because remember, as we discussed this in Sarah Boone, if this was an accident, then you can't use battered spouse syndrome. But if this was not, if this was intentional self-defense, well, then you could use battered spouse syndrome. So again, they're going to have to figure out what the defense is in this case is going to be. And I believe that I saw that they did file a notice to rely on battered spouse syndrome. And that means that she's not going to be able to argue that this was all one big accident. So we're going to have to see more how that plays out. But I think right now we're in a pretty good place to watch this status conference, this hearing that's going to happen coming up on this Friday. So that's going to be it for today. Now you're probably mostly caught up on the Courtney Clenney saga. We'll see. Maybe we'll get a trial date on that case. And join me on Friday, 9:30 in the morning, when we are going to be live streaming that status conference. Join me. We're going to be giving some real-time live analysis, and it'll be some fun. So join me then. If you haven't yet, please subscribe, like, and we will see you next time.